At the Supreme Court Tuesday, justices heard oral arguments in a case challenging federal regulations on ghost guns. Ghost guns, or privately made firearms, are weapons that can be made at home with kits or 3D printers. That means they lack serial numbers, which makes them untraceable. They also are not sold by federally licensed firearm manufacturers. Last year, the Bureau of Alcohol, Tobacco, Firearms, and Explosives said law enforcement seized more than 72,000 ghost guns between 2016 and 2022. More than 1,200 of those guns were linked to homicides or attempted homicides. After that data was released, the Biden administration redefined firearms to include these homemade gun kits, subjecting them to the same regulations as traditional firearms. It also set new requirements for firearm sellers and manufacturers. The rule is now being challenged by a group of gun owners, advocates, and manufacturers. CBS News legal contributor Jessica Levinson is here to explore this issue, or the issues in this case, all of them. Jessica is also a professor at Loyola Law School in Los Angeles, which everybody who watches this show knows because we have her on a lot. So, Jessica, let's start where we always do. What are the constitutional issues at play here in this case?
So this is a great question. It's not a Second Amendment case. John, you know this is the big gun case of this particular term so far, but it's not about whether the regulations here violate the Second Amendment. The question is about executive agency power. And the question is about whether or not the ATF had the power to say ghost gun kits now fall under this 1968 federal statute, which regulates firearms. So the federal statute doesn't ban firearms. It just says you have to be a registered seller. When you're a seller, you have to perform background checks, and there have to be serial numbers on those guns. And so what this ATF rule is trying to do is to say, ghost guns, you fall within firearms. But it's not a big constitutional case. It's a case of, and you heard the justices this morning, they talked about a lot of things. They talked about assembling furniture at IKEA. They talked about making omelets, but they didn't talk about the Second Amendment. They talked about what does the statute allow the ATF to do.
So, Jessica, is the reason they're going word by word, analogy by analogy with the statute because they're trying to determine whether what the administration did fits within the language and meaning of the statute? And if so, that's okay. If not, got to go back to Congress and have them write up some new language.
That is exactly the tension. And the lower court judge in this case and the Fifth Circuit, which was the intermediate appellate court, they said, no, ATF, you don't have the power. I'm looking at the language of the statute, and I know who can solve this problem to the extent you think it's a problem, and it's Congress. It's not you, ATF. Now they're appealing up to the Supreme Court, hoping that that they'll get a warmer reception there. I think they actually might if you listen to oral arguments, but exactly right. What the Biden administration is saying is just look at the plain language of the statute. Of course, it embraces the idea of being able to regulate these ghost gun kits.
So you listened to oral arguments. What were the justices trying to get at in those? And does that tell us anything about how this might go in terms of a decision?
So one of the big questions was about components and how components add up to a final product. And one of the first questions of the morning came from Justice Alito, and he said, well, this is a piece of paper and this is a pen. Is this a grocery list? And what he's trying to get at, I think, is a ghost gun are all these different parts. So can that really be considered to be a gun? And then they had this conversation, which I actually thought was phenomenal because here's a really important issue. And the justices are just like you and me, John. They're trying to bring this down to tell me about my life and things I use in my daily life. And the question became, what about ingredients for an omelet? Is that considered an omelet? So they're trying to figure out, you get the pieces in the ghost gun kit. Can that be considered a firearm under the statute? Finally, Justice Barrett, who I think is one of the best questioners at oral argument, because she really gets to the heart of it, said, what about a HelloFresh kit? I have all the ingredients for turkey chili. Can that be regulated as turkey chili? And the Solicitor General of the United States said to Justice Amy Coney Barrett, yes, you got it. Omelets and turkey chili. That's what it came down to.
So the question is, are the sum of the parts a whole, or are they just a bunch of different parts and you can't put them to, you can't intuit a whole, even though you got everything there for it. And the reason I'm asking you that question, which you can tell me whether I've got it right or wrong, is does this have anything to do with other cases, or is this about the idiosyncrasies of the particular language of a particular statute?
So it's a little bit about how do we read statutes? Do we read statutes broadly to embrace other areas that maybe the statute, when it was written, didn't specifically address? Or do we read statutes narrowly? To your question about the sum of its parts, where the Solicitor General really tried to lead the justices is she said, look, for an omelet, there's a bunch of things that you could do with eggs and ham and onions. But for a turkey chili kit, basically, that's what those ingredients are there for. Look at the specific purpose of the components to decide if we're going to regulate it the same way we would regulate the finished product.
Excellent. As always, Jessica Levinson, thank you so much. Much clearer now.